This is Duke University.
Welcome to Duke Law School. We seem to have gone immediately from a very warm summer into a cool fall. Nonetheless, for those of you who are from out of town, I hope you'll have a moment to walk around the campus and to see how beautiful it is. Most of you have probably been here before, but it's great to welcome you back and just for you to, I hope you'll have a chance to see how beautiful our own facility is. And welcome back my classmate from U-High, actually my brother's classmate, Erwin Chemerinsky, used to be on our faculty. So Neal Segal gets the credit for this conference, I think, or at least the lion's share of pulling it together. This is supported by the program in public law and contemporary problems, a very important journal here at the law school, and I want to come back to it in a moment. As someone who was a United States district judge for 17 years and now a law dean, I'm struck by the fact that we're having this conference here at a time when the law school has announced the creation of a center on the study of the judiciary and has begun a master's in judicial studies for judges, and when, as you may become aware during the day, as you see people with things in their ear, when Justice Alito is teaching here in the building and has been here all week. The topic itself is an extremely important one, and as we think about the relationship between the judiciary and the academy, one of the comments that you sometimes hear from judges, and it's quite common to hear this, is that academics are interested in things that are of no interest to anybody else, particularly to the judiciary. Over the summer, the Chief Justice, whom I admire and who's my friend, he said, somewhat jokingly, but not entirely, that at the Fourth Circuit, where Neal Segal was waiting to speak, that academics tend to be interested in Kant's view of justice in Bulgaria, which it sent me to the books because I wasn't sure that Bulgaria existed actually while Kant was alive, and in fact it didn't really, not as a nation state. Nonetheless, I think the Chief Justice was making a point. And I've looked through the papers here. I don't find anything about healthcare in Bulgaria in any of the papers, although I may have missed it. But I do think that probably if some of the panelists are going to speak about Kant's view of healthcare or of justice, that could be actually extremely interesting. But the point, of course, is that LNCP, with its tradition of looking at legal problems that are of immense social importance, and then the academics here are very interested in a topic that's of very great importance and of very great interest to the judiciary. Nonetheless, there's a difference in outlook. I think it's fair to say, although maybe the conference today will prove me wrong, that many or most academics think that the legal issues presented by the ACA are not all that complicated, whereas I think most judges would say, no, it's immensely complicated, and you get a sense of that from the length and the complexity of the opinions, and there's a difference in outlook. And perhaps that difference in outlook, a cynic would say, is explained by a difference in political priors, an academic might say. And that is that most academics tend to be Democrats and judges tend to be both. And so there's that difference. But of course, that might be quite a bit too simple. But it would be something to think about, and we may be at one of these flexion points in the law, conceivably, and what the explanations for the ways in which things flex will be, I think, quite interesting. And I hope that there will be better explanations than simply what was the appointing president for the particular justice, because I think it's a good deal more complicated than that. I believe, and we could talk about this at some other time, that the litigation process itself tends to neutralize partisanship among judges, because the litigation process requires judges to explain their point of view and to be persuasive and to be rational and to have true arguments. And there is within the culture of the judiciary a very great, there's a decided frowning upon partisanship. not on differences in judicial philosophy, but I can tell you over a very long career, I never heard someone make a partisan argument in the sense of how will this decision affect the outcome of an election or something of that sort. And I think for academics who also, after all, are citizens and entitled to engage in the political process, some of the same thinking may be important. That is to say, we should have that same kind of culture. And how would you create that kind of culture? Well, I think the way you would create it is to have conferences like this. So it's certainly not good enough to stand up and say, well, I voted for the president and I believe in universal health care, and therefore let me give you all the arguments that I can muster in favor of the ACA. That wouldn't be very persuasive probably here unless the arguments themselves are persuasive. And so perhaps this is the academic version of what I think is provided through the litigation system. Anyway, that's my hope, and I have a great deal of confidence in my colleague Neal Segal, and it's a pleasure to turn the podium over to him.
Thank you. Well, thank you very much, Dean, and good morning, everyone. I'm Neal Segal, and I co-direct the program in public law here at Duke Law School. I join the Dean and welcome you to Duke. We're gathered today because Congress recently enacted the largest expansion of the social safety net in more than 40 years, because the fate of the most controversial provision of this enactment will soon be in the hands of the Supreme Court of the United States, and because legal academics are contributing much, in my view, to the proper resolution of the ongoing constitutional litigation. The statute, of course, is the Patient Protection and Affordable Care Act, which President Obama signed into law in March of 2010. The ACA, as I will call it, seeks, among many other things, to achieve near universal health insurance coverage. The law requires and helps American citizens and other legal residents of this country to obtain adequate and affordable health insurance coverage. The Congressional Budget Office projects that the act will increase the number of non-elderly individuals who possess insurance by roughly 33 million by 2019, and if the law operates as intended, around 95% of all legal residents will be insured. The most controversial provision of the statute is the minimum coverage provision, the so-called individual mandate. The multitude of legal challenges to the law focus primarily on the constitutionality of this provision. It requires most individuals lawfully living in this country either to obtain a certain minimum level of health insurance coverage or else to pay a certain amount of money each year. The most significant constitutional question that's emerging in the litigation is whether this provision is within the scope of Congress's enumerated powers in Article 1, Section 8 of the U.S. Constitution. There are three potential candidates. The federal government needs only one to be persuasive to the courts in order to prevail in the litigation. They are the Commerce Clause, the power of Congress to regulate commerce among the several states, the Necessary and Proper Clause, as well as the federal government's tax power. The Supreme Court's intervention now appears very likely because there's presently a circuit split, a split of authority between two federal courts of appeals about the constitutionality of the mandate. I expect this split is going to mature in the coming months as other federal courts of appeals continue to weigh in. Most people, almost everyone in this country, has at least a financial stake in the ultimate outcome of this litigation. Many millions more have additional stakes, whether they are ideological, moral, or jurisprudential. The academics who have generously agreed to participate in this conference have much to say about the constitutionality of the individual mandate as well as of the ACA more generally. This conference is entitled The Constitutionality of the Affordable Care Act, Ideas from the Academy, because it's inspired by the belief that legal academics who specialize in constitutional law, in health law, and statutory interpretation are making distinctive and important contributions to the national debate over the constitutionality of the statute and should be encouraged to continue. It's not merely the case that some of these legal academics also happen to be very able appellate lawyers and Supreme Court advocates. That much is true. For example, Erwin Chemerinsky is a very accomplished Supreme Court advocate. But I don't think that's the only source of the contributions of legal academics. I think it's also significant that legal academics are less constrained than other legal actors by clients. I think they're also blessed with the time to study constitutional doctrine, health law, and policy for a living. They often possess interdisciplinary expertise pertinent to the proper resolution of legal problems. And among other contributions, academics, and we're seeing this now in the ACA litigation, they conduct original historical research that judges don't have the time and maybe even the expertise to do well on their own within the context of the judicial process. Academics perceive connections among different constitutional provisions, different doctrines that have previously gone unnoticed. Academics use relevant methods and insights of other disciplines to shed light on legal problems, and they bring to bear their own specialized, oftentimes highly specialized, legal knowledge to help courts of general jurisdiction decide between the client-centered arguments of generalist appellate lawyers. All of these contributions can be relevant to the outcome of constitutional and statutory cases, and this may help to explain why Supreme Court justices routinely cite the work of legal academics in their opinions. The participants in this conference exhibit the qualities I just mentioned in abundance. Included in their ranks are experts in U.S. constitutional law, history, and theory, experts in health law and policy, legal economists, and legal scholars with training in ideas and methods of modern economics and political science. These introductory words, however, can't amount to more or very much more than mere assertions. The proof is going to be in the sessions that follow. The first session, and you should all have access to an agenda which provides a roadmap for what we're going to do today, and I think that there's a roadmap that provides a coherent narrative about how the proceedings are going to unfold. The first session is going to examine the constitutional case for the minimum coverage provision, the individual mandate, from the perspectives both of legal doctrine and of modern social science. The second session is going to analyze constitutional objections to the minimum coverage provision, specifically those that stress either slippery slopes or bootstrapping problems. And we'll hear more about what both of those objections mean and whether or not they're persuasive. The two morning sessions are mostly going to adopt the internal perspective of the faithful practitioner of the law, the judge's point of view. They will inquire whether the mandate is within the scope of Congress's enumerated powers in Article 1, Section 8. The two afternoon sessions are going to broaden the interpretive perspective from which the ACA litigation may be viewed. They'll adopt, at least in substantial part, the external perspective of the analyst of the constitutional system. The third session will examine the Constitution outside the courts, inquiring whether the plaintiffs in the ACA litigation are engaged in a form of conservative popular constitutionalism, and whether political conditions at present in the United States are such that it's likely this social movement advocacy will succeed in changing the course of constitutional law. The fourth session is going to identify problems with the U.S. healthcare system that are going to endure however this particular litigation is resolved by the federal courts. It's going to view the current debate over the ACA as part of an ongoing process of contestation about the proper locus of medical authority in the United States that dates back well into the 1800s. I have many people to thank, and you know who you are. I'm going to name names at the end of our proceedings this afternoon, but now it's time to begin. Again, I bid you all a very warm welcome to Duke.
I'm Jack Balkin from Yale Law School, and this is the California Duke panel. Everybody on the panel except for me is from California or from Duke. And you ought to consider what the cultural meaning of that is. The way it's going to work is I'm going to introduce a presenter who's going to present somebody else's paper. And then that person will say, "You've completely misunderstood me." And then we'll let other people join in to explain how both the presenter and the author of the paper have misunderstood the paper. So we begin with Steve Sachs from Duke presenting Political Ideology and Constitutional Decision-Making by Erwin Chemerinsky, who is the Dean of the University of California at Irvine School of Law and a former member of the Duke faculty. Steve.
All right, thank you. I'm honored to be here and to be introducing Dean Chemerinsky as well as his paper. Dean Chemerinsky's paper makes 3 claims. First, that the Act's individual mandate provision under current doctrine is clearly constitutional. Second, that people's views about this question are highly influenced by their politics. And third, that if the mandate is struck down, the decision will have major social, political, and legal effects. I'll start by briefly summarizing the paper, which is very interesting and highly accessible, and then ask a few questions of my own. First, Dean Chemerinsky argues that the mandate's constitutionality under current doctrine is an easy question. The mandate requires every taxpayer to buy health insurance or pay a penalty, which the IRS collects along with your income tax. Now, according to current doctrine, as expressed in United States v. Lopez, Congress's power to regulate commerce among the several states includes power over intra-state activity if it's economic in nature, and if, in the aggregate, it has a substantial effect on interstate commerce. I think everyone agrees that the aggregate market for healthcare is substantial and has that kind of substantial effect. But the Act's opponents claim the mandate doesn't regulate economic activity, but inactivity, or more precisely, the refusal to engage in the kind of activity that might, in the aggregate, affect interstate commerce. Dean Chemerinsky disagrees based on unique features of the healthcare market. Literally everyone, he says, will at some point need to use healthcare. Those who don't buy insurance are making an economic choice to engage in the economic activity of self-insuring against those future risks. Upholding the mandate, in his view, wouldn't let Congress force people to do things like buy GM cars or eat their broccoli. He says that people can choose not to drive or not to eat vegetables, but they can't choose not to use healthcare. Dean Chemerinsky also argues that the mandate falls under Congress's power to lay and collect taxes. While the Act sets out a penalty for not buying insurance, courts rarely find such labels to be controlling. The penalty, he argues, applies to taxpayers, is a percentage of income collected by the IRS, and is called a tax by many members of Congress. So he says the mandate is clearly constitutional. This brings us to the next issue. Why, if the question is easy, is there so much disagreement? With some exceptions, almost all Republican-appointed judges voted to strike down the mandate, and almost all Democrat-appointed justices have voted to uphold it. The paper suggests that on certain salient issues, people are inclined to agree with other people who share their ideological outlook. Judges aren't immune to this. Their decision-making can be influenced not only by doctrine and precedent, but also by ideological orientation. So, Dean Chemerinsky says, the 5 Republican-appointed justices of the Supreme Court would be predisposed, all else being equal, to strike down the law. And he says that the crucial question is whether arguments based on existing doctrines and precedents can persuade a Republican-appointed justice to transcend the partisan divide and vote to uphold the law. Finally, Dean Chemerinsky describes the consequences of striking down the mandate. Some contentious cases, like Bush v. Gore, have little doctrinal impact in the future. Others, like Roe v. Wade, become legal battlefields for decades. A decision striking down the mandate, he suggests, would have major destabilizing effects. Many laws could be said to target economic inactivity, such as requiring food and drug manufacturers who don't want to engage in the activity of applying labels to their products to do so. And so a decision striking down the mandate might have enormous consequences. This is Dean Chemerinsky's argument, and I encourage you to read his paper. In the time that's left, I want to ask 4 questions. First, what role does the necessary and proper power play here? I would have thought that the mandate's strongest defense under current doctrine is that it's necessary to other provisions of the healthcare bill. The Act requires insurance companies to cover people with pre-existing conditions. But if people can wait until they get sick and then buy insurance, you're not going to have any more insurance companies. So the argument goes, we need a mandate to force people to pay their premiums first. Now, maybe this argument doesn't work. Maybe Congress can't just enact a terrible idea and then assert more power in order to make it a better idea. We'll have other presentations on this later today. Or maybe, as Justice Scalia has argued, the necessary and proper analysis is really of a piece with the substantial effects test under the Commerce Clause. But it seems to me that, at least under current doctrine, it's useful to look at why necessary and proper might really be the obstacle that mandate opponents have to overcome. Second, as to the commerce and taxing powers, why should we think that the question is so easy? A friend of mine noted today that we're all here today at a conference talking about the constitutionality of the healthcare bill, and normally law schools don't spend good money on conferences to talk about easy questions. The court's recent Commerce Clause decisions aren't exactly models of clarity. Lopez frequently refers to economic activity in ways that might make the distinction between engaging and not engaging in such activity, some people call the activity-inactivity distinction, have some superficially plausible basis in the opinion's text, at the very least. Moreover, it's not hard to see why a judge might want to draw the doctrinal line here and say thus far and no further. I'm not sure I agree, for example, that healthcare is a truly unique market. Almost everyone uses healthcare eventually, but the mandate applies whether or not that's so. Even at the time of Lopez, for example, almost all guns had at some point crossed state lines, which now is all that's required as the jurisdictional nexus. But if this kind of inevitability were all that's required, maybe Lopez, which involved a statute without such a nexus, should have come out the other way. Likewise, it's not clear why mandates under the commerce power would be limited to healthcare. It's true, as Dean Chemerinsky says, that no one has to drive a car, but almost everyone uses transportation eventually. And someone who just walks around and does not hail a taxi is arguably engaged in the economic activity of self-provision of transportation. As to broccoli, while no one has to eat vegetables, everyone does have to eat food. And those who do not sign up for Jenny Craig are deciding how they'll pay for that food, fee for service instead of paying premiums in advance. This might cause poor nutrition and economic harm, which states can't fully avoid by implementing their own Jenny Craig mandates. Thus, presumably, the argument might go, Congress could enroll everyone in Jenny Craig and serve plenty of broccoli. I mean, you can make up more examples. Going stargazing instead of buying a ticket to the movies is self-provision of entertainment and so on. And even you might say in Lopez itself that the defendant who brought a gun into a school zone was engaged in the self-provision of protective services. He did not hire licensed bodyguards who were capable of carrying firearms, which the law would have permitted him to do. Now, you can argue that none of this really holds water because the inactivity-activity distinction is just too thin to support this kind of weight. I think that's a fair argument. But the point is, so is the economic-non-economic distinction in Lopez. In fact, the two may be related. Virtually any activity, economic or not, involves a decision not to participate in some market. And getting rid of the distinction might bring under federal control a whole lot of activities, like walking or stargazing, that seem wildly unlike commerce among the several states. The substantial effects test could already be described as highly problematic, and the mandate is sort of the apotheosis of this test. So it's not surprising that some judges have felt very reluctant to do what they see as extending it. One quick word on the taxing power. My understanding is that of all the judges who've ruled on the mandate, Democrats and Republicans, only one has accepted the taxing power argument. I honestly don't know enough about the issue to say whether they're right or wrong, but I do think that the question seems far from easy. Third issue. What is the role of legal theory as opposed to ideology in explaining the disagreement over the mandate? However easy the mandate question might be, a bunch of federal judges and the attorneys general of 28 states have decided against it. Now, something can be easy even if smart lawyers disagree. You just have to have an external theory of how the law is supposed to work, such as reliance on precedent and doctrine. But I think it's no accident that a lot of the people who oppose the mandate don't buy into a theory of only precedents and doctrines, in which whatever the Supreme Court says goes. They're operating on a different theory. Maybe it's some flavor of originalist theory, maybe it's something else that's different. Now, people who hold different theories still make arguments based on precedents and doctrine because they want to persuade the people who are currently in power. But it shouldn't be a surprise to us that what gets mandate opponents so upset is in part a view that the doctrine has already gotten this really wrong. And if the mandate is upheld, that'll take us even further away from correct constitutional interpretation. Maybe current doctrine already supports the broccoli mandate as limited to people who engage in the activity of buying food. So this kind of disagreement at the level of legal theory might do a great deal to explain the different responses, and I'm curious as to what Dean Chemerinsky thinks on that. Fourth and finally, how broadly would an anti-mandate ruling really have to reach? The paper suggests that striking down the mandate would imperil a great deal of other regulatory environmental law. But one of the criticisms of the 11th Circuit's theory, for example, was that its distinction between activity and inactivity, or engaging or inengaging, was too thin. If the mandate had been limited to Americans who participate in the market for healthcare, which we assume is almost everyone, that law would be okay because people are engaging in commerce, and that's why it applies to them. You might think this distinction is silly, but it's also possible that 5 justices might buy it. If they did, though, I think it's extremely unlikely that 5 of them, including Justice Kennedy, would suddenly start invalidating regulatory legislation right and left. The people who make prescription drugs, for example, have to be engaging in commerce for the labeling requirement even to apply, which gives a nervous justice all the room they need to distinguish the cases. And to the extent that the mandate decision is partly driven by politics rather than precedent, it's even more implausible that justices would get rid of programs that are politically popular, even among Republicans. On the contrary, if courts end up upholding the mandate, I think it'll pose very interesting and difficult questions as to how the limits on Congress's enumerated power will be understood and interpreted in the future. So thank you for your time, and I again encourage everyone to read the paper.
I want to start by saying how wonderful it is to be back at Duke Law School. This is such a special place, and I want to thank my friend Neal Segal for inviting me to be part of this terrific conference. And I want to thank Professor Sachs for his wonderful commentary on my paper. Let me just try to address his 4 questions briefly. The first question he asked is, what role does the necessary and proper clause play? I think he's absolutely right that my paper will be strengthened by including discussion of the necessary and proper clause. I don't think that the necessary and proper clause is necessary in order to defend the constitutionality of the individual mandate. I do think it's clearly constitutional under both the commerce power and under the spending power, but I think that the necessary and proper clause is another way to get to the same conclusion. The goal of the Affordable Care Act is to provide health insurance for 50 million people in this country who otherwise don't have it. 50 million more people being insured would surely have a substantial economic effect. The Supreme Court has said, in McCulloch v. Maryland, most recently just a couple of years ago in United States versus Comstock, that Congress can choose any means that's reasonably related to carrying out its powers. Well, one way of carrying out its powers of regulating commerce would then be providing health insurance for these 50 million people, and a way to accomplish that is through the individual mandate. So I agree with you and think that should be included in the paper. The second question you ask is, why do I see this as such an easy constitutional question? And I do see it as an easy constitutional question. Let me start with the Commerce Clause. Since United States versus Lopez in 1995, the Court has articulated a 3-part test with regard to the Commerce Clause. The third part says that Congress may regulate economic activity which has a substantial effect on interstate commerce. Well, that breaks down into 2 sub-questions. Is Congress regulating economic activity? And if so, does it have a substantial effect on interstate commerce? Mr. Sachs alludes to, I think it's clear that it is economic activity, because everybody is going to need health care at some point in his or her life. We all have a choice. Either we self-insure or we purchase insurance. But either of those is an economic choice. Now, the sad reality is, for many people, there's no real choice there. They have to self-insure because they can't afford health insurance. But either way, that's economic activity. Then the question is there a substantial effect on interstate commerce? The health insurance industry is an $850 billion industry. Almost $1 trillion in the economy is healthcare. It seems to me that if Congress can regulate in Gonzalez versus Reich an individual growing marijuana for home consumption, for alleviating the effects of chemotherapy, then surely Congress under the Commerce Clause can regulate a $1 trillion industry. Now, Professor Sachs relates the slippery slope argument. Well, if Congress can force people to buy health insurance, can't Congress force people to buy broccoli or buy GM cars? And we're going to have a whole discussion in the second panel about the slippery slope. I think one thing that's omitted from this discussion is about the political checks of federalism. One of the most influential articles that's been written with regard to federalism was by Herbert Wechsler in 1954. It was the basis then for Justice Blackmun's opinion in Garcia in 1985, which says that really the protection of states in federalism can come through the political process. I think the reason we don't need to fear Congress forcing people to eat broccoli or buy GM cars is the political checks of federalism. And so I think that we can talk in the next panel about how likely is if Congress upholds this doctrinal matter, will it lead to it being constitutional to do those things? But the practical political reality is that those aren't things that we're going to need to worry about. Finally, I do think that this is clear under the taxing and spending power. Since 1937, the Supreme Court has not found any tax to be unconstitutional. The Supreme Court, ever since the United States versus Butler, a year earlier than that, 1936, has said that Congress has broad powers to tax and spend for the general welfare. The reality is that the individual mandate is a tax. It requires that people either pay a set sum or a percentage of their income. It's collected by the IRS. In every functional way, it's a tax. And if one looks at the legislative history, there are many references where members of Congress referred to it as a tax. A week ago, the United States Court of Appeals for the Fourth Circuit, in a 2-to-1 decision, found that indeed it is a tax, and therefore, under the Tax Injunction Act, the federal courts can't issue an injunction of it. If it's a tax, then independent of the commerce power, independent of the necessary and proper clause, it fits within the scope of Congress's power. Third, Professor Sachs asks, what's the role of legal theory here? And I think that's a really profoundly important question. Now, to me, the litigation over, the public debate over the Affordable Care Act is all about political ideology. Every Republican in the Senate and every Republican in the House of Representatives voted against this act. Every Democrat in the Senate and the majority of Democrats in the House voted in favor of it. The vast majority, if not all, of liberal constitutional scholars believe this is constitutional. The vast majority, though not all, of conservative constitutional scholars think this is unconstitutional. Now, is this about varying perspectives of legal theory? Is this that one side starts with originalist perspective and the other side starts with a non-originalist perspective, and that what leads to inclusion? I don't think so. I think this is an issue where it's really defined by partisanship. And that's why, as I was thinking about this, I tried to analogize to other issues that seem defined by partisanship. I thought back to December 8th, 2000, when the Florida Supreme Court ordered the counting of all of the uncounted ballots in Florida. And everybody I knew who voted for Al Gore thought that the Florida Supreme Court got it exactly right. And everybody I knew who voted for George W. Bush thought the Florida Supreme Court got it exactly wrong. And as there was speculation about what the United States Supreme Court was going to do, I remember saying, why believe that the Supreme Court justices will see this any differently from others of the same political ideology? That comment turned out to be true when the Supreme Court 5-4 ended the counting in Florida. And I don't think that legal theory or constitutional doctrine explains what the Supreme Court did. It was entirely about ideology. Think about the Second Amendment. Why is it that conservative justices read the Second Amendment as creating an individual right to have guns, whereas the liberal justices find within the Second Amendment an ability of the government to regulate guns? Is it really about one side is originalist and another is non-originalist? I don't think so. I think it is about the tremendous role of partisan ideology, at least in some issues, in defining outcomes. So I do think the question is going to be, when we think about the Supreme Court, can arguments from constitutional doctrine cause the court to overcome partisanship? Dean Levy said at the beginning that the litigation process neutralizes partisanship among judges. I don't think I agree with that, David. I think it certainly does as to some issues. It didn't with regard to the Second Amendment. The question is, will it here? It hasn't in the lower courts. All of the Republican appointees, except for Jeff Sutton on the Sixth Circuit, have voted to strike this down. All of the Democratic appointees, except for Frank Hull on the 11th Circuit, have voted to uphold this. The litigation process hasn't neutralized partisanship there. The question is, can it in the Supreme Court? I think we all want to believe that constitutional doctrine can exist apart from partisan ideology. I think this is an example that really challenges that and whether it's possible. The other thing I would say in regard to legal theory is I think what animates so much of the challenge to the individual mandate isn't what's being litigated. I think the real concern is, should the government be able to force people who don't want to buy health insurance to buy it? I think that's where the analogy to broccoli or GM cars comes in. There's some undeveloped individual freedom argument. But of course, under post-1937 constitutional law, since regulating economic activity, it's only rational basis review, so no one's making that argument. But I think that's what's animating this. And if there was some legal theory behind it, it's some libertarian notion that isn't being put in the briefs. Finally, there's the question of how broad will the reach of this decision be? And will it matter if the court draws a bright line between activity and activity? Bright lines in the Commerce Clause jurisprudence have never been successful. In the early part of the 20th century, the Supreme Court tried to draw bright lines between commerce and other stages of business. The court tried to draw bright lines between direct and indirect activity. And those lines ultimately collapsed. I think that the line between activity and inactivity will also collapse. I think it's possible if the court decides this, it will be a decision for this day only, like Bush versus Gore. There's no Supreme Court opinion since 2000, not majority concurring dissenting, that's ever cited to Bush versus Gore. And maybe that's what this will be like. But I fear not. Many have thought that Lopez and Morrison, in 1995 and 2000 respectively, were going to be a rebirth of a federalism doctrine like that which controlled during the Lochner era. We now have 5 conservative justices on the court, in Roberts, Scalia, Kennedy, Thomas Alito. They are the most conservative majority that's been on the Supreme Court since the mid-1930s. I think if the court is willing to strike down this law, then they really are going to put significant teeth into the Lopez-Morrison Commerce Clause approach, and then I think many other laws we struck down as a result.
Thank you, Erwin. Now, I will present Neal Segal's paper, Free Riding on Benevolence, Collective Action, Federalism, and the Individual Mandate. There are two big ideas in the paper. One is free riding on benevolence, and the other is collective action federalism. So let me talk to you a little bit about free riding, and then let me talk about Bob Cooter and Neal's theory of collective action federalism. Free riding. One way of approaching the policy problem that leads to the individual mandate is that there are two kinds of economic problems that are created by health insurance reform. If you currently, and so one of them we might call cost shifting, and the other we might call adverse selection. Cost shifting, as Neal was talking about, is primarily something that happens because the federal government and also state and local regulations and a long-standing practice of hospitals is to treat people who don't have health insurance when they present themselves at an emergency room. There's a federal statute on this, and then there are other regulations as well, and a practice of this. Now, this is like, Neal says, the provision of a public good. What you're doing is you're providing a mandate. This is a kind of mandate that says that a private good, access to health care, will be provided for free to anybody who shows up. So it has some of the features of a public good. And when you have something with some of the features of the public good, a natural corollary to it often is the possibility of people free riding on it. That is, so for example, people take advantage of the public good without contributing anything. And one of the effects of having the ability to go to an emergency room if you don't have insurance is many people don't purchase insurance. And they simply present themselves at hospitals and say, treat me. Now, in, I believe, 2008, it was estimated that there was about $43 billion of uncompensated care that occurred as a result of people, in Neal's terms, free riding on benevolence. Now, in fact, not all of these free riders are in the same category. Some of the people, perhaps most of them, are just too poor to afford health care. Some number, in fact, are young and are basically willing to risk nothing serious, and they also know that they'll be taken care of in disastrous situations if they can go to an emergency room, if they can get to an emergency room. So there are many different kinds of motivations, but the economic effect is the same, is that a public good is provided, then people, without contributing to the promotion of the public good, free ride on it. The second problem is the idea of adverse selection, and this is endemic to insurance markets. Generally speaking, insurance companies in healthcare have engaged in a process of underwriting. They look at an applicant, they find out what their prior health record is, they consider their age, they consider other factors about them, and then they try to make a guess based on how costly they'll be to insure, and then they provide an insurance policy based upon their guesses. Now, it turns out to be the case that people know more about their health than insurance companies do. So there's an asymmetry of information. And because of the asymmetry of information, you will not be surprised to learn that people who have private information about themselves that suggest that they will need health care either for a long period of time or in the immediate future tend to rush out and get health insurance if they can afford it. And people, on the other hand, who have private knowledge about themselves that they're likely to be relatively healthy and won't need much medical care in the foreseeable future tend not to purchase health insurance or try to put it off as long as possible. Now, the effect of that is that the people who are in the risk pool that the insurance company is underwriting will basically be weighted toward the people who have private information knowing that they'll have problems, and therefore that raises premiums for everybody in the pool. This is a very familiar feature in economics, adverse selection. Now, suppose that what we do is that we move from an underwriting model to a guaranteed issue model. A guaranteed issue model is a model in which anyone can present themselves to an insurance company and say, insure me. And we also have an additional feature, which is that there's a minimum level of what is in a health insurance policy. So you can't say, well, our health insurance policy gives you a lollipop and a mint, and you go home. That's what we'll pay for. But assume that, in fact, we have guaranteed issue and we have a minimum feature in a health insurance policy. Then the adverse selection problem is exacerbated. Because everyone knows, people will know that if I get sick, then I will go in and buy health insurance, and I don't have to do it a minute earlier. So what we have in health policy are these two problems. One caused by benevolence, the creation of the public good, the other caused by the nature of insurance markets exacerbated by a guaranteed issue rule. This brings us now to the second big idea in the paper. And the idea is essentially that the policy problems created by health insurance create a difficulty that cannot be solved individually by individual states. Why is that? Well, take, for example, first the cost-shifting idea, the idea that you'll just present yourself for emergency care. Insurance companies, hospitals are multi-state. Many corporations that provide hospitals are multi-state. Many hospitals are in cities that are near the borders of other states. Many Americans live close to a state border. Many cities are located near state borders. I'm from Kansas City. I live my parents' house is approximately, I'd say about 50 yards from the state line. The closest hospital, we live in Missouri, but the closest hospital is in Overland Park, Kansas. So, in fact, it's very, very commonplace that if people go for free care, they'll go across the state line to do it. And the hospital that's owned in Overland Park, Kansas, may be owned by a conglomerate that does business all over the country, including North Carolina and elsewhere. So you can immediately see that the effects of this kind of cost shifting can easily be interstate, and probably are interstate in a very large number of cases. That $43 billion of costs, a lot of it is going to be interstate. But then consider the second idea. The second idea is the idea of adverse selection. Now, insurance companies are multi-state enterprises, even though, in fact, they're regulated by state, individual state. And so they have to pool their profits in each of the states in which they do business. And insurance companies can choose to open for business in some states and not open for business in others, to write policies in some states or not in others, depending upon the applicable law. If a state were to go it alone and to have something like the Affordable Care Act, Massachusetts being the only state that's tried it, it faces a number of problems. First of all, it is likely to attract as a magnet people who have serious health problems because, in fact, they know that they can't be turned down, and they know, in fact, that they can get affordable insurance. On the other hand, both people who think that they'll never need health insurance or won't need it for a long time, and therefore don't want to pay it, and businesses who are afraid that the combination of regulatory impositions that would come with health insurance reform will be costly to them, might have reasons to relocate from such a state. So people might move from Massachusetts. More likely, businesses might stop writing policies in Massachusetts. This is a very familiar idea in federalism, which is the idea basically that businesses and capital will relocate to places in which the economic climate is better for them. And often, it's also true that people are mobile and they will move to places where they can get things. Conversely, of course, by the way, there's a job lock problem, which is that if you happen to be in a state that has a very good health insurance regime and you have pre-existing conditions, it's very difficult for you to move. Now, it actually turns out that my sister has this problem that, in fact, it would be disadvantageous for her to move to Arizona, where she'd actually like to move, so she stays in the District of Columbia. And I assume that her situation is not unusual at all. So in both of these cases, we have a problem that crosses state lines and is a problem that creates a policy issue that individual states by themselves could not solve. That leads me to the second big idea. This is Bob Cooter and Neal's theory of collective action federalism. And we can describe this theory both in terms of economics and in terms of originalism. First, economics. Collective action federalism idea is the idea that in a federal union, there will be certain kinds of public goods that are best provided by a national government and not by individual states. And there are certain kinds of economic and policy issues that are produced by interstate spillovers and collective action problems among states. I won't go into the details now, but simply to point this out, and to point out that under the condition where you have a good, a public good, which is difficult to keep lots of people from different states from making use of, then it's likely that it's best provided as a national public good, and therefore it's best provided by a federal government in a federated union. Similarly, if there are a series of policy issues that have spillover effects in multiple states, and in which, in fact, there are likely to be collective action problems between states regulating them, it's probably best if those policy issues are dealt with by a national or a federal government in a federal union. Now, the first part of Neal's paper tries to explain why this is exactly what we have. The cost-shifting point is about the provision of a national public good, and the adverse selection problem is the idea of a spillover effects between states that are best dealt with at the national level. Well, that's all very good from the standpoint of economic theory, but after all, this is a constitutional law symposium, and we really should be interested in what the framers thought. And I have news for you. The framers actually thought about this. In fact, the sixth of the resolutions in the Virginia Plan, which is the basis of our list of enumerated powers, was the idea that the national legislature should have the power to pass legislation in all areas where the states were severally incompetent, and also in areas where conflicting legislation by states would disturb the harmony of the union. This was the Resolution 6. It was taken up by the delegates 3 times, not once, not twice, but 3 times, then given to the Committee of Detail, where John Rutledge and James Wilson basically produced the list of enumerated powers we have today. Now, the thesis that Neal and Bob have is that it's not an accident that the basic resolution is presented in the Virginia Plan. It's not an accident that it gets translated into the list of enumerated powers. If you look at the enumerated powers closely, you'll see they are all dealing with these problems of collective action, and that the grant of powers for foreign policy, for commerce, for taxation, for expenditure, are all designed, in effect, to solve these collective action problems that are best dealt with by a federal union. And therefore, the argument they make, which is an interesting combination of modern law and economics and originalism, is this is perfectly, if I can use a slightly different word, kosher, from the standpoint of the Constitution. I have 2 questions for you. The first question is that your free rider problem is my individual liberty. Right? In other words, who says there's a free rider problem if you think that the underlying policy, which the states cannot by themselves achieve, is one which impinges on individual liberty? So, for example, let's suppose that we're back in 1920 and states have varying kinds of child labor laws, some stronger, some weaker, but most states have. And North Carolina says, we think our relatively weak child labor laws are good. They promote individual liberty and family autonomy. And what you want to do is you call it a free rider issue, but we call it liberty. So how do we know what we have? How do we know we have a free rider problem, a collective action problem, or how do we know that what we really have is a meddlesome interference with liberty? That's the first problem. Here's the second question. Massachusetts is the only state that's tried something like the Affordable Care Act, much to the chagrin of Mitt Romney. And in order for the adverse selection argument to work, it depends on what your theory of deference to congressional judgment is. If your theory of congressional judgment is rather weak, that is, or rather strong, that is, if Congress thinks it might be the case, then in fact we'll presume that there really are these economic effects. Then of course there's no problem. If Congress can make up hypothetical facts, and those hypothetical facts would lead to a problem either of cost shifting or adverse selection, well then there's no problem. But your theory of collective action federalism doesn't specify the standard of proof, and it doesn't specify the level of scrutiny. So I take it that a libertarian or an originalist like me could, in fact, completely agree with all of your economic analysis and still say that I want to insist on a very high level of proof. I want to insist on a significant degree of scrutiny for congressional judgments about economic effects. And I don't think you've provided enough evidence because, in fact, the evidence in Massachusetts and the evidence in the other contexts is ambiguous. So what would you say to someone who was willing to go with you all the way on originalism and on economics, but just simply disagree with you about the level of scrutiny?
Well, thank you very much, Jack. I think Jack states very well the two free rider problems that the minimum coverage provision is aimed at ameliorating. I think the cost-shifting rationale gets a lot more press, and I think the federal government, unwisely in my view, has emphasized it primarily. I think there's a second free rider problem, adverse selection in insurance markets, that I think also justifies the mandate. And these two kinds of free rider problems are related to two independently sufficient rationales, right, according to which the individual mandate is constitutional. The cost-shifting, or what I call free rider on benevolence problem, justifies the mandate as a commerce power regulation viewing the Commerce Clause by itself. It's commerce among the several states because it's an economic problem of collective action among the states. The adverse selection problem justifies the mandate based on the Commerce Clause in combination with the necessary and proper clause. I think Steve very astutely mentioned the necessary proper clause as a very strong argument in favor of the mandate. Others have as well. Orrin Kerr, for example, has argued that the necessary and proper rationale is, under current doctrine, in his view, unassailable. So you've got two free rider problems, two collective action problems among the several states that justify the mandate on two separate grounds. In this free rider on benevolence paper, I don't talk about the tax power, right? It's another candidate for the constitutionality of the mandate, although I will mention as a bit of shameless advertising that Bob Cooter and I have a separate paper we're currently working on in which we interpret constitutional text and history in light of economic analysis to try and provide the key analytical distinction between a tax, which is permissible under Clause 1 of Section 8, and a penalty, which is impermissible. So I think that's not something I'm focusing on in this paper, but I think it's important not to lose sight of the fact that there are three potential ways in which the mandate is constitutional. I think Jack is right to point our attention to the relationship between the federalism dimension of this constitutional debate and the muted or suppressed but palpably present individual rights dimension. Erwin, you mentioned this as well, right? You called it individual freedom, some libertarian notion that's inchoate, not entirely articulated. It has been articulated to some extent, as Brian Leach points out in his paper that we'll talk about this afternoon. There was an economic substantive due process claim made in some of the district courts, and it was rejected at the threshold, right, for the reasons that it's not 1920, right? The year insists, as Llewellyn put it, on being 2011. I do think there is a relationship that the paper addresses at the end between the federalism dimension and the individual rights dimension. Right? If one person's free rider problem may be someone else's individual right, well then articulate what the individual right is and be prepared to defend it as such. You have to overcome doctrine. That's a problem. I don't think what ought to be going on is that the individual right argument ends up being argued awkwardly and, in my view, mistakenly in the guise of limits on the commerce power. And if we don't have an individual economic liberty right to be free of an individual mandate, then why ought we to be changing Commerce Clause doctrine to vindicate the same values? That doesn't make a lot of sense to me. I don't think it's just a doctrinal problem. I think it's a problem as a matter of political morality. I think focusing on the problem of free riding on benevolence connects the federalism dimension of the debate to the individual rights dimension. The scope of the free rider problem justifies the mandate as a matter of federal power. The existence of of the problem of free riding on benevolence. It seems to me makes it very difficult to make the argument as a matter of political morality that people have a right to obtain the benefits of collective action without in any way contributing to it. Right? This is, if we think about John Stuart Mill's distinction between harm to others and harm to self, the Affordable Care Act is not primarily paternalism. It's not primarily, we just want you to take better care of yourself than you want to take care of yourself. It's that when you don't take care of yourself in certain ways, particularly when you can afford a certain minimum level of health insurance coverage and you decline to obtain it, you're imposing harm on others. You're imposing costs on others. You do this when you obtain health care, as almost everyone does, without paying for it or paying for it in full. Right? You do it by, even when you don't use health care services, you rely on the whole health care infrastructure in the country in case of emergency. Even a 20-year-old, maybe even especially a 20-year-old, can get grievously ill, right, or injured. And where is that person going? That person can rely very reasonably on other people paying for the health care that they have chosen not to insure against. So it seems to me if you're going to make an individual libertarian argument for the mandate, it's not just doctrine, it's also political morality that imposes a substantial obstacle. It's rare to find a constitutional right in this country, whether recognized by the courts as not, that allows people to obtain the benefits of collective action without contributing to it. I think the free rider problem speaks to the question of individual liberty. In terms of the level of proof, I think Jack is right that in my article with Bob, Collective Action Federalism, we are agnostic about what often will be the decisive question in litigation, which is what's the level of proof that Congress, that the court is going to apply in reviewing congressional judgments about the existence, the significance, the scope of interstate collective action problems. In free riding on benevolence, I am not agnostic. I follow longstanding Supreme Court doctrine and apply what I call a reasonableness test. This is the test of McCulloch. It was recently reaffirmed emphatically by 7 justices. Depends on how you count, but certainly a majority of the court in Comstock. 5, including the Chief Justice, reaffirmed the McCulloch deferential standard of review. You had another 2, Kennedy and Alito, who wanted something more, some kind of empirical evidence. Right? Then you had Justices Scalia and Thomas dissenting. For me, under longstanding doctrine, the question is whether Congress has a reasonable basis to believe that you've got a collective action problem among the states. I don't think the evidence is overwhelming with respect to the Affordable Care Act. I do think that the evidence is substantially stronger than it was in Raich, right? The medical marijuana case, in which Paul Clement, in his closing argument, made plausible but unproven claims about what was going on in California. Someone gets stopped with a knapsack with a scale full of pot, right? And the person claims medical marijuana, and the courts are having to deal with this. And I knew at that point in his rebuttal he had won, right? He had won the case. Right? This is not just about something plausible. There is a widespread phenomenon of cross-state hospital use, although we don't have great data on it. We have some of it. We know insurance companies and insurance and hospital corporations operate in multiple states. Some of them operate in all 50 states. When the operations and effects of an enterprise that are regulated extend across state lines, it seems to me the collective action problem is much clearer than in the case of Raich. So you have what I would suggest is a very plausible reason, although not proven reason, to believe that this problem is interstate in scope. And if the court applies longstanding federalism doctrine, that it seems to me that the ACA would pass this test. I also want to say that I want to make one more point about the paper and about the mandate. The paper is cast as a defense of the individual mandate based on both economics and constitutional law, but in defending it, the paper also articulates 2 judicially enforceable constitutional limits on the scope of federal power that the mandate itself respects. Right? So I don't think it's enough for the federal government to win this case to apply current doctrine under the tax power, the Commerce Clause, the necessary and proper clause, and say, see, it's clearly constitutional under current law. Right? They tried that in Lopez and the government lost. Right? I think it's important, if the government is going to prevail, to articulate limits on the scope of federal power that the mandate respects. no amount of applying present doctrine is going to be enough because the court gets to decide whether it's going to apply present doctrine. The court changes the law when it is persuaded that the law ought to be changed. And I think Dean Levy was getting at this when he talked about the flexion point at which we may be at, and I think Ernie Young as well in his paper this afternoon is going to focus on this. And so my paper identifies two. First, no non-economic mandates. Right? The ACA mandate is an economic mandate because it regulates economic subject matter. The way I understand Lopez and Morrison and the way I contrast it with Wickard and Raich is that the court was insisting that Congress has very broad power to regulate markets, whether actual markets or shadow markets. Congress does not have power under the Commerce Clause to regulate merely social forms of interaction, like ordinary crime. I don't understand Lopez and Morrison as being fundamentally about activity or inactivity. It's about markets versus non-markets. The ACA mandate is very much about the regulation of the interstate health care and health insurance markets. This is distinct from a mandate for everyone, say, to purchase a firearm and possess it in their home, or a federal mandate to possess a firearm in a school zone, because in the aggregate there'll be substantial effects on interstate commerce. I think it's very different than a mandate to render assistance if one notices gender-motivated violence being perpetrated in their midst. Right? There are non-economic mandates that the ACA mandate is distinct from, and that approving this would not require the court to uphold. So when you hear, as you often do, Congress mandate anything it wants if this case comes out in favor of the government, I think it's demonstrably false. The second limit that the paper identifies that Jack emphasized is that not only is there no economic mandates absent a reasonable congressional judgment of a collective action problem involving multiple states. Now, to be sure, critics will say that's not a test. That's just a way for Congress to do whatever it wants under the Commerce Clause. I don't think that's true. I think Lopez and Morrison are easily justifiable as correctly decided under the Commerce Clause based on this test. It's the same test that the court has been applying since 1937 in terms of the level of deference. So I think there are other judicially enforceable limits that I won't talk about, that I talk about in other work, but these are two important ones, and arguably the most important ones that the mandate respects.
Great. Now we have some commentators. Bob Cooter from Berkeley. Bob, what really bugs you about this paper of Neal's?
Yeah, well, what really bugs me is that my name isn't on it as well. No, that's wrong. I shouldn't say that. This is, Neal and I have been working together for a long time. And reading the paper, I was reminded of a headline in the Sacramento Bee newspaper that said, how good are Sacramento doctors? No, how good are Sacramento doctors? Local physicians rate them highly. Well, I felt quite honored to be asked to comment on Neal's paper because our thoughts are very much entwined, and I have a very high regard for everything that Neal has said. Now, I would want to reply to you, Jack. You did a beautiful job of summarizing the paper, and you ended with some criticisms of it or some suggestions of its limitations. And I want to say to you that my reply to your points go to my primary problem with all of the discussion of the mandate, and that is the constitutionality of the mandate is discussed in terms of the enumerated powers clauses. It's discussed in particular in terms of the Commerce Clause, the Tax and General Welfare Clause, and the Necessary and Proper Clause. And these are all sections of the Constitution that concern federalism. But the arguments against the mandate seldom concern federalism. I think that the suggestion that there are individual freedom arguments that are really in play, I think, is correct. Because most of the arguments are arguments against any government.
Can I change it?
Yeah.
Suppose I said the following, because I want to channel my dear friend Randy Barnett.
Okay.
Suppose I change the objection to say that it's a dispute not about individual freedom, but it's a dispute among different states about whether we have individual freedom or a free rider. So if Randy were here, he would say, look, North Carolina is not making an individual freedom claim. But North Carolina simply disagrees with Massachusetts about whether or not child labor laws solve collective action problems or impinge unduly on individual freedom. So it's Massachusetts' word against North Carolina's. So with that in mind, I've now turned it into a federalism issue.
Well, it does seem to me that the question of meddlesome interference of liberty has got to go to the parts of the Constitution that concern individual liberty and not the parts of the Constitution that concern the federal versus state allocation of powers. It seems to me that the people in one state may disagree with another in general about what individual rights consist in, about what things no government can do to them. But the fact that people in different states disagree about what no government can do to them does not speak to the question of whether Article 1, Section 8 gives Congress the power to do what it wants to do. That speaks to individual rights sections of the Constitution, and Neal and I have offered no theory of that. Yeah. I think it's very important that we do that, and we hope to get to that. But we haven't, and I would say the same thing about the standard of proof argument, because it seems to me the standard of proof argument that whether in fact there can be some whether Congress can simply believe that there is a collective action problem without proving that there is one would be enough for its legislation to be constitutional. That seems to me to be a question about the division of powers within the federal government. Neal and I have also offered no theory on that. Now, I would like to...
what do you think about the theory he offers in his paper, though? Because he really comes down in favor of pretty much weak, rational basis scrutiny.
Well, no, a little more than that. I like reasonable more than rational.
It's not rational-based scrutiny with a few vitamins taken every now and then.
No, but it's not enough to merely have a plausible rationale with no evidence. I wouldn't think that's enough. That would be enough under rational basis review. Otherwise, you can have Congress federalizing all of criminal law based on a law and economics argument that there's a race to the bottom when different states punish the same crime differently. And therefore, so I think that would unravel the entire rationale.
I really, for one, am planning to go to Delaware where the carjacking statutes are really laxly enforced.
I'd like to say something about how your question relates to Dean Chemerinsky's paper, and that's this. Neal and I really enjoy working together, and we worked out collective action federalism with great care.
Collectively, too.
Collectively, that's right. The mandate paper really is Neal's. I mean, I wish it were mine, but it really is Neal's. However, it's the case that I'm much more conservative than Neal is. And we're actually going to disagree on important matters of constitutional interpretation as a result. But we both accept the collective action federalism framework because we believe that federalism is one of the most important parts of the Constitution, and we need a theory of federalism, and this is the theory that we found that actually works. So I don't hold office, and I'm not in danger of holding office. And if I did, I suppose my views might be predicted, as Dean Chemerinsky suggests, by my political commitments. But at least the power of theory is sufficient for Neal and I to be very comfortable working together on this project.
That's great. Ernie, what do you make of all this?
Well, I disagree a little bit. So let me speak first to the relationship between the individual rights argument and the federalism argument. The original Constitution that was submitted for ratification didn't have any original individual rights provisions to speak of, right? There's no Bill of Rights, and the idea was that the structural protections in the document protected all individual rights. That was the strategy for protecting individual rights. And I think the Bill of Rights supplements that protection, but it's still the structure at the end of the day that protects individual freedom. And so it's not strange at all to argue, based on concerns about individual liberty, for limitations on the national government. And I think one of the primary functions of limits on Congress's power is to preserve space in state jurisdictions to disagree about individual rights. So for instance, Ann Althouse wrote an important piece about how Prince had the effect of preserving the freedom of some jurisdictions to protect gun rights more broadly before Heller recognized that as an important individual right under the Bill of Rights. And I think this is exactly the same thing. Think about gay marriage, for instance. There's no consensus at the moment as a matter of federal constitutional law about whether that's a protected individual right. But I think that the general view that a lot of people have, that Congress would lack power to legislate a national decision on that question, permits that sort of disagreement and ferment, and permits some jurisdictions to have a broader view of rights than others. And I think that's exactly what's going on here. So I think that's entirely appropriate. I think, you know, Neal and Bob's argument is an important and powerful argument, and it's been around for a while in some ways, but this is, I think, by far the best expression of it, the best development of it. But I want to be clear about what it's doing. So I think you can think about constitutional principles at least three levels of generality. You have the principle itself, you have the doctrine that implements the principle, and then you have the underlying values that the principle and the doctrine are meant to serve. So for free speech, for instance, you have a free speech clause in the Constitution. You have doctrines like clear and present danger that implement that principle. And then you have underlying values like self-actualization or the marketplace of ideas that we're trying to promote through the principle. I think this theory is an effort to collapse the underlying values into the doctrine. We want to apply them directly. The frustration with the commercial, non-commercial distinction in current Commerce Clause doctrine is that it doesn't necessarily track the underlying reasons why we might want to have national action on a particular question and reserve certain questions to the states, right? There's collective action problems that have to do with non-economic activity, and there's economic activities that don't implicate collective action problems, and they're very eloquent in the paper. There are there's a big problem, one big problem with implementing that as a matter of judicial doctrine, and that's that judges may not be good at these particular determinations, analyzing the level of collective action that should be required. And so I think you have two choices. You can either, well, there's lots of things judges aren't good at, and you just got to try, right? And I think that's a recipe for Lochner, right, where the judges are going to be making judgments that are equivalent to the underlying policy judgments and the laws that they're reviewing. And that's going to be a problem for courts to implement. Or you can just defer, in which case you've completely abdicated, I think, enforcement of a provision of the Constitution. And I'm not convinced, I guess, that there are enforceable limits here. I think, to say no non-economic mandates, I don't know what that means, since all activity is economic in some sense. I think they've done a very good job of showing that, and so to retreat to an economic versus non-economic distinction, I think, is tough. And the idea that it has to be reasonable, I want to know how much teeth that has. If it has too much teeth, then we have the expertise problem and the legitimacy problem. If it doesn't have enough, then you've abdicated enforcement. And then my question would be, is it constitutionally moral for the court to abdicate enforcing a part of the Constitution? And if it is, then what part of the Constitution is a very conservative court going to abdicate enforcing next? I have some proposals in that regard that I think y'all would not like.
We have time for questions, and you, sir, have a question.
I do indeed. And this is, in a way, this is a push.
By the way, when you, for purposes of recording, when I introduce you, please tell us your name and your favorite medical condition.
Matt Adler, nothing comes to mind.
Heartbreak or psoriasis, perhaps?
Absolutely.
Spontaneous decapitation.
I want to push Neal and Bob's wonderful theory and Neal's paper from a different direction. I'm really persuaded by this idea of collective action federalism as a rationale for congressional intervention, namely some kind of collective action problem for regulating among states. But you create this layer cake, right? So your view is the underlying regulatory problem requiring governmental intervention is an individual collective action problem. And in the states, governments are insufficient to regulate, and so we need the federal government. Now, I sort of wonder why you do that. I mean, certainly these days, one of the rationales for government regulation is parentalistic, right? People with more information make bad decisions, and we need government to step in. I mean, first of all, at the federal level, we see that, for example, in the food and drug laws. I mean, the best rationale for those is not free riding, when we come up with free riding explanations, it's really parentalistic. Second, I kind of find it ironic that you sort of lean on the harm principle, because part of the lesson of West Coast Hotel is that, there are no constitutional limits on government adopting parentalistic as opposed to externality-driven, or standard market theory type rationales for regulation. The other point is that if one accepts parentalism, paternalism as a rationale for regulation, you can have, races to the bottom as well, right? That too can be the underlying dynamic for a collective action problem among states needing federal intervention. So imagine that there's some activity which is dangerous to the person engaging in it, or some product which is dangerous for consumers, but consumers don't realize that. So when a state tries to step in, consumers go to other states, and so do businesses, right? So that would strike me as a parentalistically based rationale for federal as opposed to state regulation of the activities. Indeed, that may be why we have a federal food and drug set of statutes. Mm-hmm. This connects to the point, to Jack's point about the insurance mandate, which I think the description of that is free riding. Even given the required provision of care to people who are uninsured is incorrect because it really depends on whether the person who is self-insuring is judgment-proof. If I'm a wealthy person, I'm self-insuring, and I'm not judgment-proof, how am I free riding? Because if at the end of the day I show up without insurance and require care, I'm going to have to pay for that, right? And to flip it around, if I'm not judgment-proof, because I'm risk-averse and because dollars have higher utility in low health states, it's actually in my interest to purchase insurance. So by not purchasing insurance, I'm harming myself. So it seems like you sort of undercut, you're ironically sort of restrictive in terms of the possible rationales for government or regulation, and pin your, I think too much pin your understanding of the insurance mandate to this view of it as being, a ban on free riding, as opposed to something which is just in the interest of the person who's required to purchase insurance.
Mm-hmm. Matt, you see, is looking out for your interests.
So I think
you were a better theory.
Right. I think there's really 2 points you're making that I'm going to respond to. The first is the layer cake, and I think you're right. There's a collective action problem among individuals, right? And then I say that collective action problem among individuals causes a collective action problem among states. And I think you're right. That's how I'm diagnosing the problem. I don't think that's unique to this setting. If you think about the intellectual property rights in Article 1, Section 8, right, which can be justified in part on collective action grounds. When you think about the external effects on unauthorized use, that could also be a collective action problem among individuals. But the interstate effects are such that it spills over state borders. Right? There's a rationale for federal intellectual property rights not dealing with it just on a state level. You could have a collective action problem among individuals that would be dealt with very effectively on the state level if you didn't have those spillover effects. So I do think I set up the layer cake because I think that's what's going on here, and it may also be going on with respect to other problems that are within the scope of congressional power. In terms of paternalism in the harm principle, I want to be clear about the work that it's doing in the paper. I bring up Mill and the harm principle at the end when I turn from doctrine to political morality and talking about whether or not the free rider problem has anything to say about whether, as a matter of political morality, putting aside law since 1937, whether there's something to this liberty argument. And I say even if you reject, what I'm saying in effect at least, is that even if you reject paternalism as a rationale for government regulation, as Mill did, it still seems to me that there's a problem of harm to others here that ought to make us question whether or not we want to be recognizing a liberty claim. Right? So I don't think I'm saying that I'm rejecting paternalism across the board as a matter of constitutional limits. But I do think as a matter of political morality, one can reject paternalism and still have a problem with the idea that I have a right to do what I want, to be irresponsible, imprudent, when other people are being responsible, imprudent.
All I'm saying is that when you put those two parts of the paper together, it sounds like you're making this double layer cake a necessary condition for federal regulation as opposed to sufficient condition. I agree it's sufficient.
Right.
And where you have a collective action problem among individuals and a collective action problem among states regulating that, that's the case of federal power. But I deny that's necessary, because one can have a similar collective action problem among states.
Of course.
Where there's behavior which is self-harmful and individuals don't realize that. And
absolutely. What is necessary is the collective action problem among states, right? And many defenders of robust federal power are going to reject that. What is necessary is a collective action problem among the states. In this particular case, as well as in some others, you had this double layer cake. Paternalism is a perfectly sufficient justification for regulation of individuals, but it can't be just paternalism. It has to be paternalism in the context of an interstate collective action problem.
Ted.
Ted Ruger. Vitamin deficiency, which would necessitate a broccoli mandate, perhaps. Neal, the end of your response, this builds on Matt's a bit, and it actually, I think, is a difference between yours and Erwin's very nice papers. You said defenders of robust federal power would object even to that state collective action problem. I would, and I'll give an example that many of us think would be clearly constitutional, but I think is tough under your theory. An amendment to the Civil Rights Act, to the Title VII, to prohibit sexual orientation discrimination in the workplace. States can do that. About half the states have prohibited that. There's no real economic collective action problem among the states. Indeed, economic advice would suggest states should prohibit such discrimination. It's good, so there's no race to the bottom. There ought to be a race to the top. But yet what we see is states lagging behind. So suppose Congress, in some future decades, said, well, this is just national uniformity. There's no collective action problem, but it's not that states can't. It's that some states won't extend this uniform protection that relates to economic behavior. So we're going to do it. I know what you would say, Erwin, about the constitutionality there. I know what the court would say. But Neal, your theory, if taken literally, seems to say, well, that's a hard case.
Yeah, I don't think it's a hard case. I think it's an easy.
Collective action problem there.
Well,
States won't do it.
if you're gay and you want to work, do you think where you end up is going to depend in substantial part on what kind of protections there are for you in the workplace? Right? Some states will provide these protections. Some states won't. It's not that every state wants to protect gays in the workplace and it's just a problem of coordination, a collective action problem. It's that when some states do and some states don't, you have spillover effects. You have people leaving you have the kind of job lock problems. You have people leaving certain states, going to other states, people not coming to states where they'd be best situated economically and productively. So it's dealing with those kinds of spillover effects that that creates a collective action.
Would you have to?
Anything that causes people to like
one state better than another is a collective action.
Right? Doesn't this just say like any taboo public goods problem where people go to Massachusetts because it has better, more friendly policies? Suddenly,
this is a feature.
Yeah, a feature, not a bug. Why isn't it the case that in order to be a reasonable approach to a collective action problem, you'd have to show that some state might conceivably adopt or not adopt this policy because it's afraid that people will move elsewhere or otherwise the benefits will flow in the wrong direction. If every state does what it wants anyway, and it's to me impossible to believe that a state that would otherwise be inclined to protect gays in the workplace would fail to do so for fear that people might leave, then I don't see why it's a collective action problem among the states.
Okay, but this, actually I do talk about this in my commerce paper in Michigan. You're right that this is the relationship between Tebow and the question of McCulloch. That is, if there's a dispute among states, as a point of my question to him, about whether or not this is a bug or a feature, right? Because if it's Tebow, then it's a feature, it's not a bug, right? Then the question is, how do we decide among the states? One simple answer is each state decides for itself. McCulloch seems to take the view that, because for example, Maryland didn't want a national bank. Maryland thought a national bank would undermine its farmers. Maryland thought a national bank was basically the well-heeled tycoons, not on Wall Street, but of Philadelphia, were basically going to ruin small yeoman farmers. So Maryland would rather not have a national bank. On the other hand, Massachusetts and Pennsylvania did. Who decides that question? Marshall says Congress decides, because Congress in all the states are represented in Congress. So this then takes us back to a very familiar debate in federalism as to whether or not a national legislature can be trusted to basically negotiate between different states and their views about the good life. You see, but McCulloch is giving you a certain answer. That's why I say the question of scrutiny is important. There's another point too. If you're a multi-state corporation and you have gay employees, your gay employees won't want to go to states. You won't be able to send them to places in which, in fact, they can be discriminated against, where they can't marry, where they can't buy housing. This would happen with corporations in the period of Jim Crow, that basically Jim Crow imposed costs on the rest of the nation. And it also affected interstate commerce. It also affected the ability to travel in other states, and this is also true for gay citizens as well. Gay citizens may feel that they're not safe in certain states, and as a result, Congress may decide that in order to have clear channels of commerce, it decides to prohibit discrimination.
But I think the mask is off now, right? I mean, the question
when was the mask on?
Well, that's a fair question, but it just shows that even the very, very narrow limits on the Commerce Clause that are left after Lopez and Morrison are too much for you guys, and we have to have a theory that would allow everything. I mean, the critical moment in Lopez is when Drew Days is arguing, and Justice O'Connor says, General Days, if the Gun-Free School Zones Act is constitutional, then what is not constitutional? And he doesn't have an answer for that question. Game over, thanks for playing, right? And the problem is, I don't think you guys have an answer to that question. And if it's anything that causes people to like one state better or not want to move to one state or not is a collective action problem and Congress can reach it, then there is no answer to Justice O'Connor's question. And the court is not going to adopt it, which means this theory is not useful for judicial review because the court is never going to say there is no limit, and they're going to have to come up with something else that isn't going to track this particular way of thinking about the problem.
I think that ignores the economic and social reality of this case. You're dealing in an $850 billion industry. To say that Congress can regulate an $850 billion industry that affects literally everyone in the country economically doesn't necessarily tell us that Congress can regulate having guns near schools or sexual violence on a college campus. And so I think that the court doesn't need here to say that this necessarily leads to all of the other aspects of slippery slope. I also want to tie the question back to Ernie's point with regard to individual liberties, because it could be argued that a federal law that prohibits sexual orientation, discrimination, and employment limits individual liberty. The argument would be that employers should have the right to not hire gays and lesbians if they choose. That was how the 1964 Civil Rights Act was opposed, saying that if an employer doesn't want to hire African Americans or women, they shouldn't have to. That's no longer a socially acceptable argument. We don't recognize that as an individual liberty that we want to accept. I think the interesting question here is there an individual liberty that we are willing to accept? Ernie, you want to say that it's okay to talk about federalism relative to individual liberties, but what's the individual liberty here? The choice to self-insure and then potentially impose enormous costs on society? Because very few people have the resources to be able to cover the kind of medical bills they'll have if there's a catastrophic injury. So they do become free riders in that sense. But if we're going to discuss that in terms of individual liberties, shouldn't we be articulating that? And is it really any more acceptable than the individual liberty response to the hypothetical?
I think people disagree about that argument. I think they disagree about whether people should have the freedom to make this economic choice. I actually have no view on this question, but I think given that there is disagreement out there in the country, it might not be such a bad thing to allow different jurisdictions to go their own way until there's more agreement. And you experiment and you see how it works out, and that's how we come to agreement on a lot of things. That's
what
how
is the level
popular
of agreement that would be required
works
before Congress could impose a national solution?
I think the level of agreement is
But then you don't have Title VII. So remember, the problem, Steve, is that you don't get Title VII under that.
I am not equating this value with the test for Congress's enumerated powers. I don't think the doctrine can just directly implement the underlying values. And Erwin, this may not be that hard a case under current doctrine, but current doctrine is not collective action federalism, right? And then my point is shifting to collective action federalism is going to just eliminate all the limits. If you and I want to talk about, I wish we had more time to talk about Lopez
But you keep
itself.
asserting that, but you haven't defended it.
And you'll get a chance in the next panel. Thank you all very much.
Produced by Duke University. Online at duke.edu.